If it may please the court, madam, I appear on behalf of the defendant, Emcliffe House Care Home Limited, to submit an application pursuant to CPR 13.3 to set aside a default judgment that was entered against the defendant on 25th of February this year. Madam, may I respectfully ask whether you have received all the relevant documents, particularly my skeleton argument?
I have, thank you.
I'm grateful, madam. May I also ask whether you had a chance to go through these documents?
I have, thank you.
Thank you. Madam, would it assist the court any further if I provide a brief overview of the background of this case?
There's no need, thank you.
I'm grateful. Madam, I will then directly move on to the test at Civil Procedure Rules 13.3, which is the test to set aside the default judgment. And to assist the court, I have included the test in page 2 of my skeleton argument in paragraph 8. If I may summarize it for you.
There's no need, I'm familiar with the test, though. I just want to ask, is this a case where I have to consider the Denton principles?
Madam, you have to consider the Denton principle under CPR 3.9, whether the court will consider all the circumstances to deal justly with the application, and that is to ask for a relief from the sanction because the defense failed to submit this application in due time. In that sense, you need to consider Denton test.
Thank you.
I'm grateful. Madam, besides the test at CPR 13.3, I have introduced the authority of Swain and Hillman in paragraph 9 of my skeleton argument, page 2, where in determining real prospect of success, the court must consider whether there is realistic as opposed to fanciful prospect of success. Moreover, on paragraph 10, I have introduced the authority of ED and F-man liquid, which basically says that the burden is on the defendant to show that there is good reason to set aside the default judgment. Madam, I will address the first limb first to show whether there is a real prospect of success based on two arguments. Firstly, whether the claimant discharged duty of, whether the defendant, my apologies, discharged duty of care, and secondly, whether the claimant was contributory negligent. Madam, to address duty of care's issue, I have included section 2 of Occupiers Liability Act 1957 in paragraph 11 of my skeleton argument, which, if I may summarize for you, is that the defendant has a common, that any occupier has a common duty of care to discharge the duty of care. All of the circumstances relevant can be taken into account, but however, just by providing a warning of danger does not absolve an occupier from the liability. And if any independent contractor is involved, an occupier has to take reasonable steps to make sure that the contractor is reasonably competent and the work done by them is properly done. However, in contest, in paragraph 13, I have introduced the case of Rolls and Nathan, which says that an occupier may discharge such duty by providing a warning of danger. Madam, the defense submits that the occupier, in this case the defendant, did provide a warning of danger, and that is evident from witness statement of Sarah Choudhury, where she admits that she, after discovering the water spillage in this incident, placed a yellow A-frame wet floor sign, and this is evident from paragraph 9, fourth line of the witness statement of Sarah Choudhury. Madam, moreover, on paragraph 12, Ms. Choudhury says that this wet floor sign was prominent and there to be seen. Additionally, on paragraph 10 of the same statement, she goes on to say that she intended to collect mop and bucket to clean up the spillage. However, she could not do that because, as it is a residential care home, there are residents who need attention immediately or urgently in some times. And in this case, the attention needed was so urgent that later on Ms. Choudhury had to call an ambulance to take care of that particular resident. Therefore, the defense submits that the duty of care was discharged reasonably by the defendant in this case. Moreover, there was no faulty execution by any independent contractor, and this is evident from Exhibit SC1, which is Mr. Borgan's checklist, which indicates that according to the cleaning policy of this care home, a reasonable care was taken, and the defendant made sure that there is no potential hazard when the check was made last time.
Now, in respect to this, you mentioned that the defendant couldn't clean up the spillage immediately, but she made no effort to block off the area either. So has she really done enough to discharge her duty under negligence and occupiers liability?
Madam, the defense do accept that, yes, more could have been done. However, we have to also pay attention to the fact that this is a residential care home, and therefore, if I may draw your kind attention to Exhibit SC2, which indicates that there are several rooms beside the spillage with occupants living in those rooms. So if the area was actually blocked off, it wouldn't have been possible for the care workers to attend those who needs attention at that moment.
Thank you.
May I move on to make my argument regarding contributory negligence, madam?
Yes, please.
Madam, on paragraph 16, I have laid down section 1, subsection 1 of Law Reform Contributory Negligence Act 1945, which basically says that if someone suffers damage partly because of their own fault, claim shall not be defeated by reason of the fault of the person suffering the damage. However, the case of Davis and Swan Motor, which I have addressed in paragraph 18 of my skeleton argument, in case of contributory negligence, it is sufficient to show lack of reasonable care by the defendant. And in terms of determining how we should look at reasonable care, the case of Baxter and Wilcombers, which I have addressed in paragraph 19 of my skeleton argument, provides that the reasonable care in case of contributory negligences is objective, and the intelligence and dexterity of a person should not be taken into account. Madam, the defense submits that while a care worker works in a care home, there are people who are vulnerable and needs attention from time to time. And a water spillage like this could happen at any normal moment, and therefore the claimant, even if there was no sign provided, should have been reasonably careful. Moreover, she did notice when she slipped to the left of her that there was a sign placed on that place. This is evident from witness statement of Helen Williams in paragraph 8, fourth line of that paragraph. Madam, the defense submits that if the claimant was reasonably careful while going around in the premises, she could have reasonably discovered this sign, and she could have, after seeing the sign, avoided the spillage or slowed down her pace of walk. Therefore, as the defense submits that there is contributory negligence in part of the claimant and the duty of care was discharged by the defendant, the defense submits that there is real prospect of successfully defending the claim. May I move on to make my submission regarding the promptness of this application, madam?
Yes, please do.
Madam, on page 3, from paragraph 21 to 24, I have addressed these issues. And the case of Evans and Bartlem provides that a court may consider delay and reasons for it. Moreover, the case of Barron's Bridging Finance provides that even if there is excessive delay, if it is in the interest of justice, a court may allow such application. Madam, the defendant's mother was ill during the time when these proceedings took place and during the time when a default judgment was entered. And the defendant had to juggle between her mother's sick health, her responsibility towards her work, which became much more harder since there was absence from the claimant's side in the work, and her responsibility towards her 3 children. So therefore, she eventually instructed the solicitors on 1st of March, and the solicitors received the relevant documents on 12th of March. Madam, this is evident from witness statement of Catherine Smith in paragraph 5. And subsequently, an application notice was submitted just 10 days later on 22nd of March. Therefore, even if it took 27 days since the default judgment was entered to submit this application notice, the defense submits that the court may regard such delay as less of a factor. However, the defense understands that there is a sanction on the defense because of this delay, and to seek relief from the sanction, as I have mentioned CPR 3.9 earlier, the Denton test is relevant here, which is on 3 stages. On first stage, whether this breach was serious or significant enough the defense submits that though there was a delay of 27 days, it did not impact the claimant or the justice process or any subsequent hearing. Therefore, the breach was not serious or significant enough, and the claimant had good reasons for it, which is going to satisfy, as the defense submits, is going to satisfy the second stage of this test, which is why such delay occurred. Madam, I have addressed that issue in paragraph 27 of my skeleton argument. The case of Michelin News Group provides that if a claimant or the solicitor is suffering from deliberating illness, that may constitute a good reason. Madam, in this case, though the defendant was not suffering from illness, it was her mother who was suffering from illness. Still, from witness statement of Sarah Chaudhary, it can be seen in paragraph 14, last line, that her mother's ill health actually caused her to go through emotional and stressful time. And therefore, subsequently, she was late in instructing the insurers and the solicitor. And therefore, the defense submits that this constitutes a good reason for such delay to happen. Moreover, the last stage of the Denton test is in regard to whether this was done efficiently and whether the cost was proportionate. Madam, the defense submits that if claimant's contributory negligence is taken into account, this can be contested against the cost and damage awarded in the default judgment. Moreover, the claimant was paid fully for the first week of her inability to attend to work, and she received statutory sick pay while she was unable to work. Madam, this is evident from witness statement of Helen Williams, paragraph 13's last line. The second part to seek relief from sections, which is under CPR 3.9 sub 1 sub 2, such application must be supported by evidence. Madam, the defense provided the witness statement of the defendant, Mr. Brogan's checklist, which is Exhibit SC1, and Ms. Parker's record of accident, which is Exhibit SC3. Madam, therefore, the defense submits that evidence is there to support this application and support the relief from sanctions. Therefore, the defense respectfully requests the court to relieve the defendant from this sanction and allow this application to set aside the default judgment. Therefore, madam, if I may conclude, as there is real prospect of successfully defending this claim, and as this application was prompt in regard to the circumstances that are available, the defense respectfully requests the court to set aside the default judgment entered against it. If there is no further question, madam, those are my submissions.